Afternoon session of the Court of Appeals. I'm Judge Arnold Golden from Memphis, and I'm joined today on the panel by Judge Kenny Armstrong from Memphis and Judge Karma McGee from Savannah. I'm sure y'all have been before the court before and you know the routine. Each side gets 15 minutes to present your argument. The appellant, of course, has 15 minutes but can reserve up to 5 minutes for rebuttal. And you'll have to make that motion to the court, but we'll be happy to give you up to 5 minutes for rebuttal. Mr. Tisner, will you please call the first case?
Corid LLC versus Steve Hatcher et al.
Good afternoon, Your Honors. Brad Scarborough here on behalf of Steve and Carol Hatcher, and I would like to request 5 minutes for rebuttal, please.
All right, sir. 5 minutes.
Your Honors, on behalf of the Hatchers, I'm here to respectfully request that this court reverse the Davidson County Chancery Court's ruling that the Hatchers were not entitled to their mandatory award of attorney fees pursuant to TCA 20-12-119C, despite the fact that the claims against the Hatchers was dismissed. The complaint against the Hatchers was dismissed in its entirety pursuant to Rule 12 for failure to state a claim. I'm going to also address the cross appeal that was filed by Corid LLC, and wherein they're requesting that the court reverse the dismissal of the complaint against the Hatchers, and we are also requesting that this court deem that the cross appeal is frivolous.
Mr. Scarborough, let me ask you a preliminary question. Did anyone raise the fact on the attorney's fees issue that the award of cost in a motion pursuant to this statute shall only be made after the exhaustion of all appeals on the motion?
Well, it's interesting that you brought that up. I've had this issue several times, and the way that I've been experiencing it with the judges is they make a determination as to whether they are or are not entitled to fees, but they stay any award or determination of any amount of fees. So in this situation, it would have been a final order dismissing the case against my client in which the judge went ahead and ruled that we were not entitled to fees. So I was left at that point with no choice but to appeal that determination. But otherwise, if I'd have waited 30 days and not appealed that determination, it would have been a final judgment. And,
well, I was wondering about that. In other words, the issue, whether this issue on the motion itself could have been made final, and then that would be appealed, and then as under the statute, because the statute does say shall be made.
Correct.
Okay. All right.
So,
wow.
So we were.
Let me ask you, Mr. Scarborough, is any dismissal under Rule 12 dismissal for failure to state a claim? Is that your position?
Well, in this particular case, it was a dismissal under Rule 12 for failure to state a claim. And if you look at 2012-119C, it says that notwithstanding sections A or B, in a civil proceeding where a trial court grants a motion to dismiss pursuant to Rule 12 of the Tennessee Rules of Civil Procedure for failure to state a claim upon which relief may be granted, the court shall award the fees and costs. So in this particular...
But when a dismissal is for failure to state a claim, you're looking at the allegations in the complaint, and then you're sort of conceding, even assuming the allegations are true, it doesn't make out a claim. But was that the case here, that the allegations don't make out the claim, or was it because they didn't get service?
Well, it was because the allegations did not state a claim, because the motion was brought pursuant to Rule 12 based upon the expiration of the statute of limitations. Because what happened in this case is that they did not get service, and more than a year later is when we brought the motion to dismiss for failure to state a claim, because the statute of limitations had then run. So at that point in time, and we've cited in our brief the case law that provides that a dismissal based upon the running of a statute of limitations is a dismissal for failure to state a claim. So that's how this came.
What's your cite on that? I'm sorry.
I'll grab my brief 1 second, Your Honor. I believe it is on page 12 in the brief, and it's at the very top of page 12, and it says, and our brief says, as the Chancery Court correctly pointed out, a dismissal based on statute of limitations is a dismissal for failure to state a claim upon which relief can be granted. And we in the parenthetical, we quoted the trial court, but we also quoted or cited to Young, X. Rel. Young versus Kennedy, 429 Southwest 3rd, 536. So, so that was the basis as to why these claims failed to state a claim, because they were barred by the statute of limitations. So in this situation, however, the Chancery Court the court didn't find that any of the exceptions applied in 2012-119C. The court just made a determination and said, quote, the court concludes that the motion for judgment on the pleadings granted herein does not fit the circumstances of an initial dismissal of the case as contemplated by 10 Code Ann Section 2012-119C. The motion for judgment on the pleadings came after a previous dispositive motion had been filed. Well, ironically enough, the previously filed dispositive motion was this exact same motion to dismiss for failure to state a claim, which initially was denied because the opposing party requested the court the opportunity to conduct some discovery, which they did not conduct any additional discovery, and the time period for them to do that ran. We renewed the motion again based upon failure to state a claim, and that was granted. So it's our position that the legislative mandate here is clear. We've cited the court on page 12 in the brief to some other cases where the Court of Appeals has interpreted the statute and said, look, it's clearly mandatory. The court doesn't have discretion when it's a Rule 12 failure to state a claim. Now, Cored, in their brief to this court, has come out and said, well, we believe that the exception applies in 2012-119C5 capital B. And that is, the exception is, any claim that is dismissed by the granting of a motion to dismiss that was filed more than 60 days after the moving party received service of the latest complaint would not provide for the award of attorney fees. However, as we pointed out in our brief, they never got service of the complaint. So there's not a 60-day time period after service of the complaint here. So that exception does not apply. In addition, the court did not find that exception applied, and Cored did not even argue at the trial court that that exception did apply. So they're raising that issue for the first time on appeal here, that somehow this court should find that that exception applies, which clearly it does not, because there's not been service of process. The trial court found and ruled there's not been service of process and dismissed the claims for failure to state a claim. So now, Cored also has cross-appealed in this case and basically is taking issue with the trial court's dismissal for failure to state a claim based upon the statute of limitations. They presented basically 4 arguments in support of that position. Their first argument was that, well, the court just erred and we served it on someone who was registered to accept mail on behalf of the Hatchers. However, the Tennessee Supreme Court in Hall v. Haynes, 319 Southwest 3rd, 564, addressed this issue head on, and the case law is absolutely clear that if that's all you have that someone was appointed to accept someone's certified mail, that does not equate to them being authorized as an agent to accept service of process without more. And in this case, there is not more. Court has not argued that there's more. So the trial court was definitely correct in relying upon Hall versus Haynes. And I mean, it's a case on point, this exact situation. And the next arguments they made were that we were somehow, or the Hatchers were somehow stopped from asserting this defense of service of process. However, it's clear in the answer that they asserted affirmative defense number 3, the insufficiency of the service of process. Next, they argued that the Hatchers somehow waived statute of limitations, which we put in our brief, an explanation that, hey, the statute of limitation only rose the day before. So that could not be a basis as well. With that,
Thank
my
you.
time.
You'll have your rebuttal time. Thank you. Ms.
Thank you, Your
Angelo?
Honor.
Morning, Your Honors. Peter Angeloff on behalf of Ford LLC. I would like to start off with the initial service of the complaint because I think it sheds some light as I go into the rest of the timeline of my arguments. For one, we maintain that the complaint was properly and timely served. On June 25th, 2018, the complaint was filed. On June 29, 2018, certified copies of the summonses with copies of the complaint were sent via certified return receipt mail at the address where appellants later on admitted in response to paragraph 2 of the complaint that either reside or conduct business. Now, C-Coop, as agent for both appellants, signed the certified mail green cards on behalf of the appellants. So that leads into the next argument of estoppel, which Mr. Scarborough touched on briefly. On October 12, 2018, the appellants answered the complaint and asserted certain affirmative defenses, including failure to properly serve them. In response to that, on February 25th, 2019, we, on behalf of the appellees, on behalf of Ford, sent interrogatories, requests for production of documents, and requests for admissions. Specifically, in the interrogatories, we're inquiring into the basis for the third affirmative defense in appellant's answer, which is the failure to properly serve them. And in addition, in the interrogatories, we were asking the appellants to identify the home address to the extent that is different from the one that they admitted to in response to paragraph 2 of the complaint. We never got responses to those. On April 9, 2019, we were forced to send a good faith discovery dispute letter to opposing counsel. May 10, 2019, appellants filed a motion to be excused from Local Rule 18 or, in the alternative, for a scheduling order and to set the case for trial. As of late May, having not heard back with respect to responses to our discovery requests, we're forced to call and email counsel for the appellants. Finally, on June 4, 2019, we got to have a Davidson County Local Rule 22 conference over the phone with counsel for appellants. Counsel for appellants specifically represented to us that the responses to our discovery requests, specifically the interrogatories, which are inquiring into the basis for the affirmative defense, were ready and were just pending final review. In addition, during that June 4, 2019 conference, counsel for appellants specifically represented the responses to our discovery requests will be provided no later than June 10, 2019, which, by the way, is within a year of us filing the complaint. Now, responses to the interrogatories and requests for production documents were not provided to us until September 6, 2019. Instead, on June 27, 2019, one day after the 1 year had expired, we get the first motion for judgment on the pleadings. Now, it is abundantly clear that when appellants held the conference, they had absolutely no intention of actually providing responses to our interrogatories. And such conduct should not be rewarded.
Are you taking the position that there's nothing you could have done between the time that you became aware that they were making that affirmative defense until the time ran? I mean, how many months was that?
I would say it was 8 or 9 months. The position I'm taking is that what we did in response to getting that answer with the affirmative defense is send out discovery requests, specifically interrogatories, inquiring into the basis for that affirmative defense. And again, when they filed their answer to our complaint, they admitted to paragraph 2 that they either reside or conduct business out of where we send the complaint. Since we didn't get the responses to the interrogatories, what we did is send out the good faith letter and then follow up with emails, phone calls, and then the conference call, which we're required to have under the local rules prior to filing a motion to compel. Again, we were reassured that we'll be getting responses to those interrogatories, one of which was inquiring into the basis for the affirmative defense and asking for the home address of the appellant if it was anything different. We were assured we'll get those by June the 10th, and we didn't get them until September, well after the 1 year had run. Now, with respect to waiver, and counsel for appellants touched on that briefly, I understand why appellants could not have raised the statute of limitations defense back when they filed their answer on October the 12th, 2018. I get that. The 1 year statute of limitations cannot run. But what should have happened, we present to the court, what should have happened is appellants should have filed a motion to amend after the 1 year statute of limitations had run, amended their answer to include that affirmative defense, the statute of limitations affirmative defense, which has to be well pled within the answer, and then should have moved for a dispositive motion, whether it's a motion for judgment of the pleadings or something else. That never happened. Appellants never asked the court for permission to include the affirmative defense of statute of limitations in their answer, and the court never granted that. And for that reason, they've waived it.
What did the trial court say about that?
Well, obviously the trial court agreed with appellants, and you have to forgive me, but I don't recall exactly what the trial judge said about that specific aspect of it.
Is there any authority for your position that they had to first file an amended answer and assert the defense of statute of limitations, as opposed to simply after the statute had expired, doing what they did, which was filing a motion to dismiss because the statute had expired?
Judge Golden, before I respond to Judge Armstrong, I just wanted to say, I think part of the reason is that the waiver defense was raised during oral argument, which can be found in the transcript, volume 1 at pages 20 to 24. And Judge Armstrong, to your question, Tennessee law is clear that a defendant waives his ability to rely upon the statute of limitations as a defense if he fails to timely and properly assert that defense in his first responsive pleading to the plaintiff's complaint. And for that proposition, we cite the Steed versus Realty case. Obviously, one can file.
Is that a situation where at the time that the lawsuit is filed, the statute has already expired, so you're required in your answer to assert the defense of the statute of limitations? But in this case, the statute had not expired when they filed their answer. And you can file a motion to dismiss without ever filing an answer if you have a basis to file a motion to dismiss.
Sure,
but
but
they did here, isn't it? Rather than filing some amended answer asserting statute of limitations, they simply filed a motion to dismiss based on the statute of limitations.
that is what occurred here, yes. And we've raised one more argument in our brief, which I won't touch on. I'll let you review that. I'll move on to the attorney's fees so that I make sure that I cover that portion of it. Counsel for appellants already covered that, but essentially what the trial court rule is that the motion that was granted does not fit the circumstances of an initial dismissal as contemplated by the statute, and further held that it came after a previous dispositive motion had been filed. Now, specifically, appellants filed their answer on October the 12th of 2018. On June 27, 2019, they filed their initial motion for judgment of the pleadings, which was denied on August 13, 2019. They then filed their renewed motion for judgment of the pleadings on October 1st, 2019.
That first motion was denied based on the fact that you had indicated to the court you wanted to take discovery, as I recall. And that's the basis on which the motion was denied, to give you an opportunity to conduct discovery, which according to the briefs, you never did. But that was the basis for the denial of the motion. Is that your understanding?
That is correct, Your Honor, yes.
So what is the difference between the first motion and the second motion, other than the fact that the court denied it based on your desire to take discovery?
It raised the same issue, so there is no difference in that. The difference is that they filed the answer, filed a first motion, and then filed a second motion.
So it wasn't dismissed. It wasn't dismissed on the merits of the motion. It was dismissed on your request to take discovery.
That is correct, Your Honor, yes.
All right.
We maintain that the trial court's interpretation of the statute is proper and entirely consistent with the wording of the statute. And then counsel for appellants briefly touched on the exception that we bring up in our brief, which states that the statute does not apply to any claim that is dismissed by the granting of a motion to dismiss that was filed more than 60 days after the moving party received service of the latest complaint. We maintain that appellants received service of the only complaint we filed on July 29, 2018. Now, going a step further, we maintain that whether service was proper or not does not matter with respect to the 60 days. If the legislature decided to put language in there that says receive proper service or anything else of the like, they could have done that. The reading of the words in the statute indicate otherwise. So we maintain that the trial court properly denied the request for attorney's fees. That is all I have for you, unless you have questions for me, which I'll be happy to answer.
I don't see anyone requiring to ask a question. So thank you very much for your argument.
Thank you.
Mr. Scarborough, you have 5 minutes.
Thank you, Judge Golden. Just real quick on the contention that service was accomplished July 29, 2018. That argument disregards the fact that the only way to accomplish service is pursuant to the rules of civil procedure. And the only way to accomplish service of an original complaint is pursuant to Rule 4. And that is exactly what the court has ruled here that never took place. Now, of course, after service of the original complaint and summons pursuant to Rule 4 is accomplished, you can serve people pursuant to Rule 5 of the Rules of Civil Procedure via U.S. mail, facsimile, now via email and things of that nature. But in this case, we're talking about the only complaint, the original and only complaint and summons, which was never served pursuant to Rule 4. So clearly the only way you could construe that statute that talks about service of the complaint, or it says the latest complaint. But here we're talking about the original complaint. So the only way to get service of the original complaint is pursuant to Rule 4, which they did not do. And so, without a doubt, there's no service. So 60 days has not passed since service. So the motion is the exception of 60 days would not apply to this particular situation. Now, I just want to quickly hit on the contentions, and you heard a lot of discussion about these interrogatory responses. Well, what you didn't hear is the interrogatory response that they received was basically a reiteration of the affirmative defense number 3. It said the same thing. Hey, you don't have service. They had over 8 months to do whatever they needed to do to get service. I mean, going and requesting an alias to be issued is a pretty simple thing to do when someone sends you an answer and they put an affirmative defense in there that says, hey, insufficient service of process. The people you served were not authorized as agents to accept service. It was completely within their control to do whatever they wanted to do. So it's a red herring to say that they needed interrogatory responses to know what the basis of the affirmative defense was. Under Rule 803, affirmative defenses, they shall affirmatively set forth facts as the basis for them. And this is the reason why. So you don't need to look to prejudice. You don't need to look to go through discovery. Your affirmative defense is your affirmative defense. And in this situation, we told them exactly what they needed to know. They even sent a discovery, an interrogatory question about it. So they knew it was there. They saw it. They had 8 months. They were in complete 100% control to do anything about it. And they did nothing. And that's why the court did not adopt or did not accept their argument that there was some excusable neglect in this situation. I know we didn't hear any argument about excusable neglect, but I do want to hit on it because we had to brief that in the cross appeal. And they made the conclusory statement in their brief that the trial court abused its discretion in not granting them additional time due to excusable neglect. Well, what they didn't do is they didn't cite to any single basis for why the trial court would have abused its discretion. In our brief, we lay it out that basically a court abuses its discretion when it causes an injustice to the party challenging the decision by 1, applying an incorrect legal standard, 2, reaching an illogical or unreasonable decision, or 3, basing its decision on a clearly erroneous assessment of the evidence. They did not even argue that any of those 3 bases were present to overrule the court's discretionary decision to not grant them additional time in which to get service reissued. Better yet, we lay out in the brief in our request for attorney fees as a sanction for a frivolous appeal on the cross appeal, the fact that there's really no basis to allege that there was a waiver of statute of limitations. Statute of limitations is a Rule 12. It's a Rule 8 defense, which can be brought by a Rule 12 motion. And a Rule 12 motion for failure to state a claim can be brought at any time. So the fact that we didn't first ask the court to allow us to amend the answer to assert this new defense that came up 2 days before and then file the motion, it would have made no difference. We would still have asserted the defense. They couldn't have gone back and undone it. So there's no basis for that argument. And with that, we would request that the court.
Let me ask you, though, at the time that the claim was filed, was it a claim upon which no relief could be granted? At the time of the filing, not 10 months later, but at the time of the filing?
No, I think that at the time it was filed, it stated a claim.
Okay.
Any other questions from the court? Thank you, gentlemen. We'll get to work on this and get you an opinion as soon as possible. Thank you for your argument.
Thank you.
You're free to go.